Hello and welcome to the Sidebar presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for a decade. We are recording this on Friday, July 19th, 2024. In this week's episode, the senseless death of a child after her father allegedly left her in a hot car because he was distracted while playing video games. Plus, a defendant accused of murdering his mother and the family dog with a hatchet who's refusing to appear in court on alleged religious grounds. But first, a former ballerina pleading self-defense in her husband's murder as potential jurors are screened to deliberate the contentious trial. Today, we are joined by Andrea Burkhart, a criminal defense attorney experienced in trial and appellate litigation, and an accomplished legal commentator you can find on YouTube at Burkhart Law. Andrea, welcome to the show.
Thanks so much for having me.
I got to admit, I'm a big fan. I've been watching your YouTube channel. I was telling you beforehand, but I figured I would tell you here so everybody could hear it, that one of the things I really enjoy about your analysis is that you let the trials speak for themselves. I think that a lot of people who get into kind of analyzing courtroom drama like to bring a little drama themselves, but I really appreciate your very even-handed approach to these cases. You're obviously very experienced, and your analysis that shows through with all of your analysis. So thank you so much for coming on.
Well, thank you so much. I really appreciate it.
Absolutely. And I know that you have been following these cases in particular closely. So let's go ahead and jump right into them. First, out of Manatee County, Florida, all eyes have turned to a former ballerina charged with her husband's murder set to stand trial as her attorneys contend the case is one of self-defense. Ashley Benefield was flocked with supporters as she appeared in court for final motions ahead of her second-degree murder trial for the death of her estranged husband, Naval Commander Doug Benefield. Benefield died of 2 gunshots in September of 2020. Ashley ran to a neighboring home in the wake of the shooting, claiming that she had been attacked by Doug, The couple, who were married 13 days into their relationship, were in a contentious divorce after 4 years of matrimony, both fighting for custody of their daughter. Ashley claims that Benefield was abusive in the relationship and that he charged her in her mother's house when she shot him. However, investigators allege that Benefield was facing away from Ashley when the fatal shots were fired, throwing major complications into her defense. Last year, a judge denied a motion to dismiss the charges under Florida's Stand Your Ground law, paving the way for an eventual trial. Jury selection is underway as you're listening to this, and we will update you as the trial develops. Andrea, first, Florida has this really unique law. It's not unique in other states to have a concept of stand your ground or this idea of, self-defense. But Florida has this unique law in that there's a determination made by a judge on the idea of self-defense, on the idea of stand your ground before it even proceeds to trial. Could you talk to us a little bit about that and why that's kind of unique, and then why you think that the judge allowed her to proceed to trial in this case?
Sure. Well, this is a unique procedural setting because normally the jury is the one who decides what the facts are in the case. They hear the evidence, they make the determination of whether there is self-defense or not under the circumstances. And so in most states, stand your ground typically just means that a person who is where they have a right to be has no duty to retreat. They are entitled to use force to defend themselves proportionately against a threat of physical harm. So Florida's situation is unique in that it allows this kind of weeding out process of, I think the intention is to target cases where there really isn't much dispute about whether it was self-defense or not. You could think of, for example, an armed robbery, a carjacking, something that's caught on video, where it's pretty crystal clear what the circumstances are. And so in that situation, it's not just for the benefit of the public, who then doesn't have to go through the expense of the process and the trial and everything, but also naturally for the victim as well, to not have to not have to be kind of put through the ringer that the trial process can often be in that situation. So it is a unique situation, and the determination here that she's not entitled to that defense as a matter of law, it's not preclusive. It doesn't mean that the jury can't still make that determination. It just means that the judge did not find these circumstances so clear cut that it could say, as a matter of law, she was entitled to act in self-defense in this situation.
I'm so glad that you explained it that way. And I think it's important for people listening to understand that it's not that a judge determines, I don't believe that applies here. I don't think that you've reached the threshold for my determination, and therefore you're not allowed to argue it. They're going to argue it. We're going to hear all about self-defense. It's just, as far as a judge, like you said, kind of acting as a gatekeeper, is they're going to allow it to proceed to trial. And this is not entirely uncommon as a concept, because, we have preliminary hearings, which are determinations of probable cause. There are ways to challenge a finding in a preliminary hearing and ask another judge to kind of sit in review of what was done in the preliminary hearing. So there are kind of these gatekeeper processes along the way. But Florida kind of has this unique one that applies specifically to that stand your ground, which you explained very well. So thank you for that. The other part of this case that I imagine we're going to see is kind of the cousin of self-defense, which is the battered spouse defense. And that I imagine she's going to make her and her defense team much of this case about kind of the abuse that may have been taking place in the household, or allegations of that, and how this was a powder keg waiting to happen type of situation, which led to this tragic end result. How difficult are those cases, though, to defend in court?
Oh, these cases they can be extremely difficult because oftentimes you're dealing with some very complicated dynamics when you're talking about abusive or toxic types of relationships. The tendency of the criminal justice system, where we're categorizing people as perpetrators or as victims, it tends to be very black and white. And the problem is that these relationships often aren't. And so juries can really struggle with how do they categorize the events that they're looking at, the evidence that they see, and the choices of the people that were made before them for them to evaluate. So it's not an easy defense at all to bring. Typically, there's going to be an expert. I've seen cases where an expert will do things like they'll analyze the communications between the individuals. They'll analyze if there have been prior police reports or reports of other incidents of violence and things like that, just to get a sense of what the dynamics were. Because the problem is a lot of toxic behavior in these relationships. It can get mirrored back. And so it becomes very difficult to pinpoint what is kind of the triggering cause, and who is the one that's reacting to an abusive dynamic. So I don't envy the defense attorneys in this case. There's just a lot of red flags around this relationship altogether, but I think it's going to be challenging, depending on what the facts are that they have to work with, to potentially convince the jury that this is somebody who is victimized over the course of this relationship.
Yeah, I think you're right that bringing in an expert can sometimes not only be powerful, but almost entirely necessary to explain this, because jurors do what all of us do, is we start to put ourselves in the position of the defendant. We start asking ourselves, how would I behave? And a lot of folks who are not familiar with this cycle of abuse and how it really works say to themselves, I would have walked away. Well, why didn't you just walk away? Why didn't you just leave him? Why didn't you call the police? Why didn't you do, all of these things that seem like on the surface, and if you have no experience with it, to be very logical steps that one might take. But unless you're involved in that environment and involved in that cycle of abuse and understand the gaslighting and everything else that can take place, you don't appreciate how this could culminate in something like this. Not that I'm saying that's what occurred here, but I'm saying if you're going to go with that kind of a difficult defense, you better be able to help people understand, get inside a person's mind. Last question I had on this is the couple's daughter. Again, oftentimes lost in these tragedies are, husband kills wife or wife kills husband. And now one of them's dead and the other one's going to prison away to prison forever. And the children are left with no parents. And so, again, we find ourselves with one of those situations. But she has appeared in support of her mother outside the courthouse and in news interviews. She's a very young child still. How do you think that one, just her presence in court might have on this case effect, if at all, or even if she takes the stand, what effect do you think that could have?
I think that anytime you bring a child into the courtroom, it's a very high risk strategy because there's very much the potential that it can backfire. On the one hand, there's a natural inclination to see the child as somebody who has an inside view and is best positioned to really understand the nature of what was going on in that home that led to this terrible incident. The problem, though, of course, is that the child is still a child, and the child is viewing this with the maturity of a child. And anytime you're going to put a child in a situation where they're kind of being expected to view things as an adult, act like an adult, adopt the perspectives of an adult, that can backfire. There can be situations where people consider it very inappropriate to put a child in that kind of a position, to be sort of standing in as judge of the child's own parents at a stage in life when that child should be free to develop and have its bonds with both parents and grow and form the child's own opinions and judgments about the life process. So I think there is certainly a potential for it to be beneficial to Ms. Benefield, but at the same time, I do think that there is a risk that you can sometimes turn off a jury with an approach like that.
Yeah, they're going to have to walk it's like a tight wire, high wire act to really kind of walk that very fine line. Well, like we said, this case is beginning just now. Trial is going to be ongoing. We will, of course, continue to follow it and give you all updates as they arrive. Let's move to Dubuque, Iowa, where a murder trial is underway, minus the defendant, for a man charged with killing his mother and the family dog with a hatchet. Jennifer Daisy suffered 17 axe blows to the head and body before succumbing to her injuries, and was discovered by a friend who called 911 after seeing copious amounts of blood in Jennifer's home. When officers responded to the scene, they found her son, Tyler Daisy, asleep in his room, naked. Daisy was immediately placed under arrest, allegedly telling authorities that he killed his mother because she was practicing witchcraft. The man was initially found to be incompetent to stand trial. However, a judge ruled in May that he was ready to face charges, though Daisy has failed to participate in the proceedings thus far. Daisy, who identifies as a Freemason and Jewish Nazarite, penned a letter describing his refusal to appear in court, saying he would not make himself a slave to the law. Okay. In the absence of their client, Daisy's defense faces an uphill battle attempting to poke holes in the prosecution's case to sow reasonable doubt with jurors. Whether or not he appears in court, Daisy faces life in prison without the possibility of parole if convicted. And moments ago, before we sat down to record this podcast, Daisy was in fact found guilty of all charges after only 2 short hours of deliberation. His sentencing date has not yet been set, but like we just said, he is facing mandatory life for the murder charge. All right, Andrea, a little less for us to chat about now that the anticipation of what was going to happen here has been foreclosed. Not that I think that that was a big question in anyone's mind when you've got a 17 hatchet wounds and a house full of blood and he's asleep naked saying that he killed her. Not much for the jurors to really dig into on that. But it does raise a very interesting issue here that I wanted to kind of ask if you could help us walk listeners through, is this idea of competency as opposed to insanity. So he's obviously, I think, suffering from some mental issues here. And at one point he was declared not competent, and then a judge found him competent. But that's not really what we're talking about when we're talking about insanity. Could you kind of, pull that all apart for us?
Sure. So competency to stand trial is really focused on a defendant's ability to understand and knowingly participate in the court process. And so it's looking at things like, is he able to communicate with his attorneys? Is he able to realistically understand what the situation is, what types of risks are present, what the trade-offs are? It's much more of a functional type of evaluation that's done with competency than there is with insanity. And so it's very common for people who are in a mental health crisis to be just not particularly high functioning. There's been decompensation to a point where, there can be paranoia, there can be hallucinations, there can be just a lot of different problems going on that make just rational engagement very, very difficult. And so it's very common in that situation for those people to go through what's called a competency restoration process, which typically means you're confined to a mental hospital and you're medicated. And typically just it takes as long as it takes, but often for types of mental illness that are responsive to medication, you're just basically in a process of getting them stabilized so that they can continue now to function on a more normal level, and then from that point make the decision themselves about whether they want to participate in the process. Insanity is quite different because it's a very high bar. The standard to prove that you are insane, you're not guilty by reason of insanity, is that at the time you committed the crime, you were unable to distinguish between right and wrong. This is an old common law rule that goes back hundreds and hundreds of years. So it doesn't really reconcile very well with kind of modern mental health understanding and just the symptoms that we know and understand and stuff like that. So it's a very limited category of dysfunction that is going to qualify for insanity. If you know that it's wrong, but you think that, for example, a God or a demon or Satan or something is compelling you to do it, that's not always going to make the standard. If you think that it's wrong, but you have hallucinations, voices that are commanding you to do it, you're paranoid and you're afraid that if you don't do it, something terrible is going to happen. These are not going to meet the standard. They might establish a certain level of incompetency that would require restoration. But because there is still that core moral understanding of the difference between right and wrong, it's not going to satisfy the very rigorous standard for an insanity defense. So very, very difficult, particularly in a situation where the defendant is not cooperating with the defense to be able to establish insanity.
Very excellent. That was done so well. I really appreciate that. And how it applies to this case, too, and what you were referencing is what we've talked about on this show many times before, which is the McNaughton rule, which is the rule that they use in Iowa. Different states apply different kind of standards, but McNaughton is kind of this controlling idea that, like you said, goes back to forever ago, which establishes this idea of distinguishing right and wrong. So applying it into this case, no evidence that his mother or the dog was participating in witchcraft. Yet he's saying that he acted out of this belief that they were. He's got these kind of bizarre religious ideas. He identifies as all sorts of, what was it? He identifies as a Freemason and Jewish Nazarite. Okay, fine. Obviously, someone suffering from delusions, from a mental health crisis, whatever you want to call it. I'm not a psychologist, but what the prosecution, I'm sure, was able to point out here was, in spite of all of that, he knew what he was doing was wrong. And as long as that can be established, then you can go ahead and find him guilty. Am I putting that the right way for viewers and listeners?
Oh, I think that's absolutely correct. And so often in cases like these, that's just proven by the actions that are taken. So, for example, steps to avoid being detected, other types of actions that would imply that the person knows society will look down on this action, because then that reflects an internal understanding that what was done here was wrong. So it is fairly common for that to be proven with different types of objective evidence in the case.
Yeah. And yeah, it's a really funny, not funny is not the right word. It is a interesting kind of corner of the law to really get into, because you see situations, as I've experienced situations. I was involved in a case where the person fully believed what they were doing was the right thing. In other words, they had killed their father because they felt that was for the benefit of all of humanity, that they were saving the world by doing that. But they also knew that they would get in trouble with the law for doing it. So he ran from the police. He knew that he had done something illegal, and that was enough alone to kind of get past that threshold for insanity purposes. But again, an interesting case. It has now been resolved, and we will, of course, keep you all updated as to the sentencing. Let's move along to our final case out of Tucson, Arizona, where a father faces charges of second-degree murder and child abuse after allegedly leaving his 2-year-old daughter in a hot car to die because he was, quote, distracted while playing video games. According to a criminal complaint, Christopher Schultes left the child to sleep in the family's SUV while the vehicle was in direct sunlight on a 109-degree day. Schultes didn't discover the child until the wife came home from work asking where the daughter was. The couple brought the girl inside, attempted to call 911. It was tragically too late, however. New details unveiled in the criminal complaint suggest that this was not an isolated incident, but a pattern of behavior. According to police, in the wake of the girl's death, authorities interviewed Schultes, 2 other children, who allegedly told police that they were regularly left alone in the car by their father and that the man, quote, got distracted by playing his game when their sibling died. In text messages exchanged between the couples, Schultes' wife firmly placed the blame for the death on her husband, saying, "I told you to stop leaving them in the car. How many times have I told you?" Schultes reportedly responded, "Babe, I'm sorry." Later adding, "How could I do this? I killed our baby. This can't be real." Appearing in court last week, Schultes pleaded not guilty to the charges, and his wife has since defended him publicly, insisting that the father is not a risk to the public and expressing her desire for her husband to return home, allowing their family to begin the grieving process. Andrea, these cases sometimes, especially the ones involving children, when it's so just tragic and avoidable and senseless, really bother me. But we're talking about here criminal liability. And so I want to kind of keep the conversation to that. I think we can all agree this is awful. We can all agree that we are not happy with this man. But how are they going to, or do you think there will be any issue in establishing the intent required for second-degree murder here?
I think that it's potentially a challenge. Second degree murder is normally an intent type of murder. It just means that it's not premeditated. But sometimes second degree murder can also be what they call grave indifference to human life, which just basically means it's an extreme level of recklessness, such disregard of a risk as to effectively mean that you knew what you were doing. And so because of that, the line between murder and manslaughter can be quite thin sometimes. Manslaughter is also another form of homicide that's typically a reckless act that results in death. And so with a situation like this, from an intent standpoint, it seems very difficult to be able to establish that. This does not seem like a situation where the gentleman intended to kill his child. It was a terrible accident. He made a terrible mistake. He's clearly got some bad habits as far as supervising his children and getting a little too caught up in the video games and so forth. But at the same time, the risk is really undeniable. I mean, just given the context here, this is Tucson. This is the middle of summer. The heat in that car is going to be a situation where you just know everybody knows what type of risk that could present, and so to not set an alarm or something just to make sure that the child is going to be safe in these circumstances, that the child isn't going to be forgotten. I think it just depends on the extent to which the jury looks at that and appreciates the scope of the risk and its inclination to, I think, judge him for the steps that he could have taken but didn't, and essentially how much do they think that it shows a kind of depraved heart, a severe selfishness, as opposed to just, obviously terrible situation, but more of an oops than something more severe.
Yeah. Yeah. And again, I hear everything you're saying, and I agree with you. And again, I will say, and I think I'm speaking for both of us, that we're disgusted and troubled and heartbroken by his behavior and what that led to. But again, we're talking about, how, getting now down to proving this and the elements in court. What is there going to be difficulties here? And I think I agree with you, because we're really walking that line, that not entirely distinct line between accidental and intentional behavior, or, like you said, grave indifference to the life and safety of others. An interesting thing to me here, it would be, well, first of all, would let me ask you this. First of all, would it change your mind if this were an isolated incident? In other words, there is evidence that he may have done this in the past. Mm-hmm. Let's say none of that existed. In a hypothetical, if this were the first incident that this had ever happened, would that change your mind about how, whether or not you think they should even proceed with this case?
Well, I can see how it could. I think, unfortunately, in these situations, it's not that common that somebody is going to not be charged at all. I think it just becomes a question of, is it going to be a manslaughter charge or something more serious? Simply because you can't get around that this is a death. Somebody died as a result of this conduct, and so that is extremely serious and has to be vindicated. But at the same time, I think we all recognize that if you can put yourself in these shoes where everybody has been absent-minded from time to time, and nobody ever thinks that they could be like that towards their child. But if you could just put yourself in that situation where, for whatever reason, your attention is divided, you didn't get very much sleep, you're being torn in a bunch of different directions, and you just forget, you will be destroying yourself forever for the rest of your life for that mistake, because it's something you can't ever take back. And so one of the things I'm interested in this particular case, I'm interested to see if he testifies. And part of the reason why is because I know it's often the majority view among attorneys anyway, that it's better for the defendant not to testify. They obviously don't have to, can't be compelled to. But from my perspective and my experience in practice, there are often situations where it's really important to do that. And so in a situation like this, where that man's motivation, that man's heart, that man's remorse, that man's regret, these are all things that could very much be on trial just as much as the fact of what happened, which frankly doesn't really seem to be like it's that much in dispute. And so given that, under these types of circumstances, it just makes me wonder if that is a strategy that they're considering so that he can essentially humanize himself, throw himself on the mercy of the jury, and just try to do what he can to get them to put themselves in his shoes.
Yeah. It's a case that bothers you on a very emotional level, but again, it's not a clear-cut case on a very legal kind of intellectual level. Mm-hmm. One thing I'm interested in is the time, if they're able to establish the time that she was in that vehicle. And apparently there is some evidence that they can tie it together, and it's approaching the 2-hour mark there. Mm-hmm. Again, if we're trying to figure out, is this go beyond a person being absent-minded and making a mistake into the realm of gross negligence and indifference, mm-hmm. that amount of time that you're not even thinking about your child, I think would play into that. And so I imagine prosecutors will highlight that as well. Mm-hmm. Wow. Well, on that incredibly sad note, we will continue to watch this case, but that is our discussion for this week. But it has been a pleasure speaking to you, Andrea, and I wanted to thank you again. Where can people find out more about you?
So you can find me on YouTube, as you mentioned. It's at A. Burkhart Law, and also at Twitter and Instagram. I'm under the same handles, A. Burkhart Law. I also have a Substack that you can find me, Andrea Burkhart. That's a little bit more long form, and I do a little bit more in-depth legal analysis of cases that I'm looking at. So that's the kind of thing you're interested in. Stop on by there as well.
Fantastic. And I encourage everyone to please check her out wherever you can. In the meantime, I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, you can also check out my brand new YouTube channel, Courtroom Confidential. And of course, you can find all of our Sidebar episodes wherever you get your podcasts. And we want to hear from you. If you've got questions or comments you would like us to address, tweet us your questions with the hashtag TCN Sidebar. And thank you again for joining us at the True Crime News Sidebar.